It's a good thing I noticed that the recording was off, so it's on now. I can't see the chat box. Oh, there you go. Okay, got it. Okay, good. Okay. How about Annalie? Annalie, are you able to type your answer in the chat box as well? Okay. Okay. Okay, so we got the answer from Annalie as well. So we have a dissenting opinion here from Annalie. Can I get one of those who form the majority to explain your opinion?
Yeah, I'm happy to. From what I can read of the question, there's been no following of natural justice at all. Whatever the Mr. Lamb hasn't been able to give his side of the story. He hasn't been able to represent himself at all. They've just issued a fine with no real recourse. There should at least be an opportunity for him to tell his side and have it decided on an unfair by a fair and unbiased party.
So I've got a few. I'll begin with the first question, Andrew. Are you suggesting that every time an administrative decision maker makes a decision, he has a duty to actually observe the rules of natural justice?
I believe that he does. I could be wrong. He or she should obviously follow the basic principles of natural justice. It should be an impartial decision. There should be a chance to have for the other party to at least give their side of the story or to be able to appeal the decision.
Okay, let's put it this way. Let's assuming that you took a test, whatever it might be. It could be to become a registered accountant or a registered social worker. And the results came out, and you're unhappy with the results. Would it mean that assuming that the marker did so as part of the executive, as part of a regulatory framework of the executive government, are you suggesting, Andrew, that marker or examiner has a duty to accord you natural justice? Meaning that you should have been given an opportunity to be heard before the marks were released?
After, definitely. And that's my point in relation to there being, on the scenario on the screen, there seems to be no recourse. We're not going to give you back your items until you've paid the fine of $10,000. I suppose if there was an avenue here for appeal or the decision to be overturned, then natural justice could be followed.
So you're suggesting that in the example I gave you of the examiner, you would be making a strong suggestion that examiner should actually hear you first before he or she would release the results.
No, what I'm saying is there should be an avenue for recourse after the results have been released. So if you're not happy with the decision after, then you should be able to have that examined. For Mr. Lamb, now that this decision has been made, he should have an avenue for appeal, not just has to pay a fine.
Hold on. Wait. Get me. Hold on. Something's playing here. Really? Can you get the iPad? Interesting.
Sounds like my.
Yeah. So just to clarify your point, so are you saying that if there were an avenue, if there were a recourse after a decision were made, in the example that I gave you about the examiner, if there were a recourse to have somebody review the results, would that have an effect of the examiner not having to accord you natural justice? Or regardless of whether or not there was actually a recourse to a review process, the examiner owes you an obligation to observe the rules of natural justice in any case?
The examiner, I'm going to be honest that I haven't looked at this week's work, so I'm just going off my head here on what I think it should be. But I would think that the examiner would need to have in place a system that allowed for natural justice to be applied. So the examiner makes their ruling being, that you got 10% rather than the required 50%, and then from there you can appeal that decision to an unbiased party.
I see. Okay, thank you, Andrew. Was there anyone who wanted to amplify or elaborate on what Andrew may have said, or would like to explain his or her answer?
I'm happy to explain mine.
Yes, go ahead, Janet.
In regard to Cooper versus Board of Works for the Wadsworth District, even though it's a very old case,
yes,
it was similar in that the Act was silent as to a duty to accord natural justice. Interestingly, Earl CJ, although he quantified this with "I think," so it was his opinion, nonetheless, he couldn't conceive that any harm would occur from the board hearing the party first, even though the Act was silent, because the result was so tremendous for, in this case, Mr. Cooper. He felt that in giving his opinion that it would have been fulfilling the statute to provide Mr. Cooper an opportunity to explain why he hadn't followed the rules.
Okay.
That is in terms of what that particular context was.
Yeah. So going back to the specific facts, thank you, Janet. Going back to the particular facts, so I'm not gonna make a comment yet on what you asked, Janet. I'll do that in a short while. But going back to the particular facts of this discussion question, I'm just gonna twist the facts a little bit, okay? Let's assume I was thinking that I was speaking too fast. So let's assume that instead of the agency seizing the documents, what the agency was planning to do was to inspect the documents and the papers and the goods and the other assets of the unregistered business. Okay, so this time, I'm just changing the facts a bit. It's not about seizure of documents. There is a plan on the part of the agency to examine and inspect the documents, papers, goods, etc. The question is, in that scenario, the new scenario that I gave, was there a duty on the part of the agency to provide a notice first to the company that it was intending to inspect or examine the documents? In other words, it will be invalid for the agency to just suddenly, come to the office of the business for the purpose of inspecting or examining the documents. So in other words, given what Andrew earlier said, are we making the point that the agency would still have to accord natural justice to this commercial establishment if the purpose of the agency was merely to inspect? I'm not sure if the word merely is correct. If the purpose of the agency was to inspect or examine the documents, papers, goods, etc., would there be a requirement to accord natural justice, at least about the requirement that there should be an opportunity to be heard. So I'm asking that question because Andrew was saying that in all circumstances, an administrative decision maker seems to have an implied duty in all circumstances to accord natural justice. So I'm just trying to clarify this notion of natural justice.
Yeah, Manjo, just on what I think, again,
Yes.
would be that they only need to afford natural justice if they're making a decision or there's an outcome. So
There
I
is a
wouldn't
decision there. There is a decision there. They're about to inspect documents. That is a major decision. Imagine, an agency coming over to your office to examine, to inspect your books. They will be determining, the amount of sales you're doing. They may be able to determine who your customers are. They'll be able to look at your bank accounts. So there's a concern somehow about, privacy. So the question is, would there be a duty to accord natural justice?
May I?
Yes, Annalie, go ahead.
Yeah. There's provision in the legislation here that gives this statutory power the authority to seize goods and documents.
Yes.
They have already been given that power to do so. The same as we'd say for a tax agent, for example.
Yes.
They also have the right to turn up on the doorstep of a business and seize their papers to investigate. If you had to tell people that, we're coming in 2 weeks' time, it's quite likely that there might be a misplacement of certain documents. That would certainly not defeat the purpose of justice.
Now, what we need to notice is that this act is silent on whether prior notice must be given by the agency. So the scenario would be different if the act said that no prior notice should be given. And I'll ask a question on that later on. But the act here is silent on whether prior notice must be given. So in that second scenario about the seizure, and I address the question to Annalie now. Annalie, assuming that we follow the same set of facts, that the act is silent on whether prior notice must be given, are you suggesting that despite the act being silent, there would be no duty to observe natural justice? Or would the duty only come in if the act expressly states that there must be a duty to accord natural justice?
No, I think that because the Mr. Lamb here in this instance has breached the act. So I don't think that he'd be the right person to jump up and down and say, but they didn't apply to the act.
Good point. So
I think the keystone here is that he's breached the act. If he had all his registrations in order and he was running a legitimate business, then he might have a complaint.
Interesting. So you're suggesting that assuming that a company or a person is in breach of statute or a law, then it is permissible for an executive agency to just come in and seize documents and papers and goods, even if the enabling act is silent on the issue of according natural justice. Because
the act might be silent on that issue, but it's not silent on the issue of giving the power to seize the goods and papers.
Yeah, let's assume that the power. Yes. So let's assume the power is clear, that the agency has the power to seize the documents, but it is silent on whether or not the power to seize must be exercised only upon giving the person or company that breached a law the prior notice. So the power is there to seize, but the law is silent on whether or not prior notice must be given. So my question is, Annalie, would your answer be the same if the law is silent on whether prior notice must be given? If you say if the person or company whose goods are to be seized are actually in breach of the law, like in the facts here. Annalie, what do you think? Or
Just thinking.
Okay.
Just thinking about that one, but yes, I would still stick to my answer. I still think that he's breached the regulations. Then he's not in a position to demand that the government will stick to, or that the authority will stick to the rules when he hasn't done it himself.
Okay, we've got an opinion from Patrick here. Remember, what we're talking about is something that can affect us, right? So Patrick is saying silence is irrelevant. The decision maker must always show natural justice. Okay, Janet, you've just inserted something in the chat box. What is the point that you were trying to make here?
Point I'm trying to make here is that there was actually a fine. It doesn't say exactly what it was for,
Yes,
but there was a fine involved here, and I just think that's something that needs to be considered in the whole picture. He could get his goods, documents, etc., return on payment of a $10,000 fine, which seems quite a bit when there hasn't been any notice given at all, for example. So just looking at balancing the scales, that seems a little bit of an irregularity to me.
So
I can't find a case that looks or confirms that, but it does seem a tad unfair if he has no say, but yeah, give us 10 grand and we'll give you your goods back.
But if you compare that to, say, a speeding fine or a parking ticket, nobody's going to ring you beforehand and say, listen, I noticed you were speeding the other day and I'm just about to issue you a fine. Are you okay with that, or do you have something to say before I post this thing?
Right. In fact, a lot of these...
It's not a fine, though. It's for the return of his goods and documents. It's in exchange for something. Whereas a traffic...
Yeah, we're actually talking of two different things. But I like what Anneli was saying, because on occasion, we do come across police officers where they hold their speed cameras and they don't really notify the public that they're about to, enforce speed laws. And you begin to wonder, do they owe us a duty to inform us that they're actually about to apprehend those who are overspeeding? And yet, if they do tell us in advance, it defeats the whole purpose. Because
the weird thing is,
yeah,
in New South Wales, Manjo, apart from police officers,
yes,
in all other speed cameras must be signed, including the mobile fixed cameras, like the ones that are in the backs of utes and stuff like that. The only ones that aren't, that have an exemption from a requirement to pre-tell you that you're about to be checked, are the ones in police cars.
Okay. Did anyone else want to say something before we try to answer this question? I mean, before I give my suggested answers. Yes. Paul.
Hi, Manjo. It's Paul.
Yes.
I'm sorry I'm late.
That's fine, Paul. Go ahead.
Mate, I've come in a little bit late on this, but if the legislation states that they can confiscate and etc., that's fine, but that doesn't automatically give them right of entry. They can't enter your premises without some kind of authority, confiscation, issued by a judge. So, I mean, could we go back on the legality of the entry?
Okay. Interesting. Well,
so if they haven't given notice, they've obviously provided no documentation.
I will just add a fact that let's assume that the agency is empowered by the Act to actually enter the premises without getting a warrant from a judge. So the agency has its own power, has been given a power by the Act to enter the premises. Would that be invalid?
I tend to think it would be, especially if the business was operated from a house. It's not a commercial entity. Nobody can trespass on your property without some kind of authority, and where the legislation could... But
the authority has been supplied by the legislation.
But this is what I'm saying. Can it give blanket approval just to enter any premises that they see fit? I don't think it can. I think it could be challenged.
So it would be invalid.
I think so. I think
in other words, you're suggesting that, again, we're kind of changing the facts here, given what Paul has contributed. You're suggesting that before police officers or agency officers could enter premises, especially if it is a house, they must first inform the occupants.
Yes,
they must first give the occupants an opportunity to be heard that, we are about to enter your premises. These are the allegations. Are you okay with this?
Yeah, if they have an actual legal document that says they can, such as a warrant, issued by a judge, they've got to present that. That's notification.
This isn't, as I said, the law says the agency has the power to enter premises without having to secure a warrant from a judge.
But this is what I'm saying. A warrant is notification. So now you're saying that these guys are above the law. They can just enter any premises without notification.
That's the question. Hold on. How can you say they're above the law if the law is the one which is saying they could actually do this?
Yeah, that's a valid point. I'll give you that. But I think, no, they must have some kind of notification. And if that's an authority through the legislation even, but I don't think so.
Okay, good. So I think we've kind of exhausted the discussion here. Unless Matt would like to say something.
No, okay, I'm caught up with you. I'm listening in, so.
Okay,
Thank you.
fine. So let's try to answer this question, and then we can follow through with the other facts that we introduced into the scenario. So the basic rule is that there is an implied duty. So meaning there is a duty, okay? It is implied. So there is a duty on the part of decision makers. So even if the law does not say it, there is a duty that is implied. It is a duty that is implied that decision makers must afford natural justice. If the acts of the decision maker will affect rights, interests, or legitimate expectation. So the context is the implied duty to accord natural justice only occurs in the context of the decision or the action of the decision maker affecting or infringing or impairing rights, interests, or legitimate expectations. So that is the general proposition there. I'm going to write it on the screen, okay? So there is an implied duty on the part of decision makers to accord natural justice where the decision will impair rights, interests.
Manjo, can you reduce the size of the screen, please? I just can't see what you're writing. That's all.
Oh,
please.
It's now on the chat box. Can you see it? Or
Yes.
am I able to put it on the screen as well? Let me try to put it here. Can you see it at the bottom of the screen? Okay, so that's the general proposition. So let's apply it now to the case. So the answer here is correct. Okay, that the action of the agency is invalid because the actions of the agency involves the seizure of documents, papers, and goods, which impaired certain rights of an unregistered business. So in other words, I think it was Andy who was saying, it is not actually correct that simply because somebody or a person or a company may be in violation of a law, it doesn't mean that that company or person loses rights. The rights are still there. They must be observed. So the rule of natural justice must be observed. But, this is the but, and this goes back to the issue of Andrew. So it is not in all situations that natural justice must be accorded. So in the scenario that I gave earlier, and I think Paul and Matt were not yet here then, I gave a scenario where in the context of a regulatory framework, somebody was taking an exam to become a registered nurse or a registered architect, for example. And then the question was there a duty that before the results were to be released, that person must first be heard? And the answer is no. Okay? In that new context of an exam as part of a regulatory framework, there is no duty on the part of the examiner or the marker to accord natural justice or to provide prior hearing to the examinee about the results before the results are released, because in that context, the examinee has no right. He has no right to be admitted as a registered accountant, architect, or nurse. It is still something that he has to prove, and that is by passing the examination. So until that point that he passes the examination, there is no right. Neither is there an interest or a legitimate expectation. Okay, so let us be clear. There is no implied duty on the part of decision makers to accord natural justice in all instances. It is only where the decision will impair rights, interests, or legitimate expectations. Now, what was one of the other things you were saying? So now, because that is a common law rule, okay, so it is a common law rule. It is a rule that has evolved through the centuries by judges. Because it is a common law rule, it can be displaced. It can be replaced. It can be displaced by an enactment of Parliament. In other words, if Parliament passes a law saying that there is no duty to accord natural justice, then there is no duty to accord natural justice. Clear enough? What was that clear? Clear. Questions? So we can proceed. We'll proceed to the next question. Good. Okay. Patrick, can I ask you to read the discussion question again?
Yes. During a TV interview with James Colt for the televised Colt Report, Minister of Immigration, the Minister, Scott Tomlinson, said, "As Minister of Immigration and Border Protection, I have very strong reservations about people applying for Australian resident visas who claim to have an empathy and claim to be a good and honourable men, despite having committed serious crimes and atrocities in the past as jihadi fighters abroad. These people are heavily radicalised by their war experiences and pose a potential danger to our community, even if they may appear respectable today by running a string of businesses in Sydney or elsewhere." About a month after the TV interview, Omar who owns a profitable chain of laundromats in Sydney, received a letter from a delegate of the minister informing him that his application for an Australian permanent resident visa had been denied on account of evidence that he had committed serious crimes and atrocities in the past as a jihadi fighter abroad. The letter stated further that, notwithstanding the character references and evidence presented by Awadi that he was a changed man, the minister was of the view that Awadi is an excluded person under the Migration Act 1958 Commonwealth. Awadi has come to you for advice as a solicitor and believes that the minister was biased against him. Advise Awadi as the minister's decision may have been affected by an actual bias as shown by his statements and whether there may have been a breach of natural justice.
Thank you, Patrick. When you're ready, please post your answers in the chat box. Oh, from Annalie. Annalie, hold on, where's that? 613. Oh, there you go. Let me just, was trying to copy and paste it, Annalie, but as soon as I do that, there, lost it again. Oh, you can't copy and paste either, because as soon as you type as soon as you try to copy and paste it, yeah, it gets overtaken by others who are typing their own. Okay, we'll give it a few seconds. So, are we all done? Let's see, Janet, Annalie, Paul, Annalie, Matt, and Patrick. So for Andrew, you would be saying that there would be a breach of natural justice, Andrew. Matt, if you could.
I would say that there could be a bias shown there.
This is Andrew
But
speaking,
again,
right? This is Andrew
yeah,
speaking.
it is.
Okay, yes. Or
Yeah,
Paul.
it is. No, Andrew.
Yep, go ahead, Andrew.
We don't sound anything alike, and I'm far better looking than Paul. I would argue that he certainly, the minister certainly has expressed his opinion that could be seen as a bias. He says he has very strong reservations about people in that situation. Not that there is evidence that people in that situation, are heavily radicalised and that they are a potential danger to the community, etc. He's just saying that it's his opinion. So certainly you could argue that he has a bias against those people.
And just to clarify, because he is biased, in your opinion, then he has breached the rules of natural justice?
Yeah, yep.
Okay. Patrick, on the other hand, says that there has been no bias shown by the minister. But isn't it a fact, Patrick, that the minister here is saying that he has very strong reservations about people applying? Yeah?
He is, but when he's saying that, he's making a statement in the media, but this is not forming part of a decision pertaining to Mr. Owaldi's case.
I see. Okay. So,
Manjo, it's Paul. I'd even go further there to say that he can say he has very strong reservations, but he's saying that as the minister. I mean, it's his decision. So as the minister, he can have very strong reservations. He's not saying that it's his personal belief or understanding.
Okay.
In his role.
So what is the significance of the poll? What's the effect? Is he...
Well, I think, if I ask... I'll give you an example. If you're a police officer and I turn around to you and say, the guy down the road that keeps breaking into the houses, what do you think? As a police officer, he's going to say, well, look, as soon as we get the evidence, we will arrest him and charge him. If I'm standing there at a barbecue and ask him and he's not wearing a uniform, he might well turn around and go, yeah, that little bastard, I'm going to get him as soon as I can, The opinion is different being professional and unprofessional, and he was speaking as the minister.
Okay. Therefore...
I think that his view, he's saying, in my role as the minister, I have very strong reservations about these people that are applying because of this legislation.
So therefore, does he have a bias or not?
I don't think so. I think he's just saying, look, this legislation says this. I have very strong reservations about people that are applying based on this.
Oh, Janet. Janet, tell us about that. Janet. Janet?
Yes.
Yes?
Yep.
You seem to have come across an important case there. Can you tell us?
Yeah, I actually read. Yes. I read Justice Dyson Hayden's 67-page report, which did this rather brilliantly. The question is not whether a decision maker's mind is open. Oops, did I put too blank? Decision maker's mind is blank. It is whether it is open to persuasion. It doesn't mean that the decision maker does not have their own opinion. It is whether or not they can put any prejudgments aside for the decision that is at hand. Also, in the comments that were made publicly by that particular minister, they were applying to a class of persons and not to Mr. Owaldi in particular. So it wasn't a personal thing. It was general.
To answer the question, what is the answer? I mean, it's evident to me what the answer is, but can you just state for us, Janet, what your answer to the question would be?
It is neither actual bias nor perceived bias, according to what I feel, and the readings that I've looked at.
So therefore, there would be no breach of natural justice.
There would be no breach of natural justice.
Okay, that would be the correct answer. So that would be the correct answer, because it's, you know, you can hardly, it's difficult to imagine a situation where a decision maker does not have an opinion one way or another. Everyone is opinionated. You know, you and I, we have opinions of our own. We have prejudgments of our own even. We have biases of our own even. The mere fact that we may hold prejudgments, we may hold biases, we may hold prior opinions, does not mean that we will necessarily violate the rules of natural justice, for as long as we are actually capable of altering whatever biases or prejudgments or prior opinions we may have. So it is only when our biases, our prejudgments, our prior opinions are unalterable, they're only when they cannot be changed, that there can now then be a complaint that there would be a breach of natural justice. But for as long as we keep an open mind, that is fine. There will be no breach of natural justice. Is that clear? Clear? And that's following the case of Minister for Immigration versus Gia. Oh, I was just trying to think if there was something that we needed to clarify here. Now, however, let me just make an important point here. Okay. We make a distinction between executive officers of the Commonwealth that are ministers, as opposed to other officers of the Commonwealth who are not ministers. The distinction is ministers for immigration, for example, belong to the cabinet and they are part of the Commonwealth Parliament as well. And therefore, because of the notion of accountability, whatever decisions they make will likely be subject to a review by the cabinet or even by a review by members of Parliament itself. So for that reason, ministers have a wider latitude to express strong views on certain subjects that may affect the interests, the rights, and legitimate expectations of people. So let me repeat, executive officers such as ministers have, because of the idea of parliamentary responsibility and accountability, they have a wider latitude to express very strong views that would make people think that their ideas or their opinions or prejudgments are unalterable and are therefore fixed. So they have a wider latitude and scope. However, if you are an ordinary officer of the Commonwealth, meaning you are in an appointive position, let's say you're the manager of the Department of Social Services, it is totally something else for you to be making a strong opinion, because if you do, there might be an idea, an apprehended bias, that you are in fact, your opinion is in fact unalterable. And in that case, there might potentially be a breach of natural justice because you are biased. So there is a distinction in that special case. And we also examine the context in which statements may have been made. So if a statement was made in jest, if a statement was made in a casual conversation which was overheard, again, this influence a determination of whether or not a decision maker may actually be biased to such an extent that there might be a breach of natural justice. Questions? None? Okay. I prepared another question which isn't in Moodle actually, but I prepared another. Yep. So that's the correct case there, Matt. And thank you, Janet, for that. The case is Minister for Immigration and Multicultural Affairs versus Gia. Thank you. I just have a final. Hold on. How do I do this? So I just have a final discussion question that I'd like us to go through. Having a hard time trying to reduce the font size. Patrick, I suppose you're still there, aren't you?
Yeah, still here.
Can I ask you to read the question for us, Patrick?
Yes. The Australian Meat Commission, a government agency created under the Australian Meat Commission Act, Commonwealth, announced a vacancy for a position of meat inspection supervisor. Jill Patterson applied for the position since its position description matched her.
Sorry, wait, what's going on here? Why am I being logged out? I just want to make sure that you're still recording this. What's going on? We'll just cancel this. I was just getting a notice that I was getting logged out.
It's all right. It still shows it's recording, Manjo.
Okay, that's good. Okay, sorry, Patrick. Go on, please.
That's all right. Yep. Jill Patterson applied for the position since its position description matched her credentials perfectly. As she expected, she was interviewed for the position by a panel headed by the Commission's Executive Commissioner and learned that she was the leading candidate for it. Jill was greatly disappointed later to receive a letter that she had not been successful in her application. She also found out that a junior colleague who had reported to her and was fresh out of university got the position. She wrote to the Commission's Executive Commissioner to ask why she failed to get the position, while someone else who lacked certain qualifications for the position was accepted instead. The Commissioner wrote back to say that they could not discuss the reasons for any hiring or non-hiring decisions. Jill wonders whether her right to natural justice has been breached and has come to you as solicitor for advice. What will you tell her?
Okay. So think about that for a while, and when you're ready, please type your answers in the chat box. Due to privacy reasons from Emily. Okay, you got the answer from Andrew. Okay, it's interesting. The breach of privacy here is coming up. Okay, go. Yep. Just waiting for the answers from the others. So Janet, it seems to be Janet here is having an unfair advantage over us. Every time we attempt to find an answer, she comes up with stronger authority. How can we dispute that? She has her authority. Nice. However, if she was the leading candidate, oh, okay, but she made a qualification there. Interesting. Very good, Janet. I'm very impressed. Do we have the answers from everyone now? Paul has said something. We're just waiting for Matt. We could probably begin, Matt?
Yeah, go ahead. I'm still catching up.
Yeah, okay. So where do we begin? Okay, who would like to explain his or her answer?
Paul, Manjo, it's Paul. I'll have a crack.
Yes.
Just to annoy everyone. I think privacy comes into it because you can't disclose information regards the other candidates. You can't say why somebody got a job over you without disclosing personal, or not so personal, but private information about another candidate. I know it's away from natural justice, but I just thought I'd bring in the breach of privacy just to mix it up.
Let's just assume that you requested the executive commissioner to release the results only in relation to you, just for them to explain the reasons why you were not chosen, without having to inquire about the status of anyone else. So, in other words, there would be a breach of privacy in that case, would there?
Well, it could well be, because you're now asking for not personal, but information to be released by individuals or from individuals on the panel, but they would probably consent. I think that's a different scenario, but in your scenario, she's asked why this other person got the job based on her experience.
Right. Because there are two requests there. The first request was to why. It was a question was why somebody else got the qualification. Got the position. I see. Yeah. Paul. So assuming that the question is changed and her only request is that she be given a reason or reasons why she wasn't chosen, because she had assumed that as she said here, her credentials perfectly matched the position description. And so therefore she expected to be appointed, and she wasn't. So her only question was, so I'm changing the facts a bit now. She's not asking the executive commissioner to explain why someone else was chosen. All she's asking the executive commissioner to do this time is to explain why she wasn't chosen.
Sure. Mm-hmm. All right. I'll take the privacy off the table in that case. Yes. I think she has the right to ask. I don't know whether she has the right to the information, though.
Okay.
I can't quite. I can't quite Janet's case because I haven't read it.
The critical question here is it's not so much just a question of right. It's really a question of a right to natural justice. That's the question.
Yes, no, I understand that, but like I said, I think Janet's case will answer that question. I haven't read it, so I can't refer to
Janet, would you like to, because you have a qualifier here now, so what are you saying here?
Sorry, I was typing, but I was typing too slow. Look, again, just going from real life stuff, most times the state and Commonwealth governments state that if you want feedback, that you are entitled to receive feedback. Now, that doesn't say it in the scenario that you've given, but I would expect that this would apply in this case for feedback on her application only, not to ask about the other person, because that simply wouldn't apply. And it also depends, because some applications do have appeals are available and others no appeal is available within government spheres. So without knowing whether that was available, if that was available to her, she would be quite within her rights to appeal. If it wasn't, the best she could hope for, without anything else having been written, said or implied, was that someone may give her feedback.
Okay.
Yeah, Manjo, it's Andrew. Can I just jump in for a sec?
Yes, go ahead, Andrew.
I'm just speaking from a state point of view, which is where I've got my experience from, and I'm not aware if the Commonwealth has the same legislation. Yes. But in New South Wales, we have an act that states clearly that public sector employees are entitled to natural justice in relation to decisions that affect them. And it goes further to state that in relation to promotion decisions, an appeal can be lodged, but that appeal can only be made on the basis of the recruitment and selection process was flawed or deficient in some way. So you can't argue that person was better than me, but you can argue that there was a flaw or in some way the recruitment and selection process was deficient. However, again, it's really strict on who can and can't apply. You need to be a public sector employee already, and the other person who got the position needs to also be a public sector employee. So it's really, but without that legislation being in place, I don't think there'd be any avenue for natural justice or any appeal.
So what is your answer to this question here?
So I suppose if there's no legislation specifically granting that avenue for appeal or that avenue in relation to natural justice, that it wouldn't exist. And from what I just read there of that case, obviously the Commonwealth does not have or might not have legislation that mirrors what the state has. So possibly natural justice doesn't have to be followed in this type of situation.
Okay, let me just clarify. What was the reason why she did not have a right to natural justice? Was it because the law did not expressly provide for her to be given a right to natural justice? Was that the reason?
That's my take on it. Unless there's legislation that specifically grants it, I can't see why it would exist.
But my question is, I thought earlier we had discussed that there is an implied right to be accorded natural justice. So case law is clear that decision makers have an implied duty. In other words, even in the absence of an enabling legislation, there is an implied duty on the part of decision makers to accord natural justice in certain situations. So,
possibly what I should be doing then is paying more attention and less eating of my dinner.
okay. So what's the answer here? Was there a breach or not? Breach of natural justice?
I have no idea now.
Okay. So going back, in relation to the implied, so in other words, there is no requirement that the law must state that the rules of natural justice have to be observed. It is an implied duty. So case law is clear that there is an implied duty on the part of decision makers to accord natural justice, but only when their decision would affect or impair rights, interests, or legitimate expectations. So in other words, if the decision of a decision maker will not be affecting rights, because let's say in this case, the basic question here is, in the case facts, the question is, does Jill have a right to be appointed to the position? Or does Jill have a right to receive a letter? Now, obviously, it's clear she has no right to be appointed to the position. She doesn't. Right? I mean, she's still applying for it. The context I think that Andrew gave earlier was in relation to public sector employees in New South Wales, and these were already employees. So if you apply for a promotion, or let's say questions of somebody being terminated. So if you change the facts, and instead of an appointment, you're talking of a termination from employment or from a position, that is something else, because when you terminate the employment of a person, you are now depriving that person of his or her rights. And because if it involves a termination, therefore, and because it affects a right of a person, definitely the rules of natural justice will have to be observed. But in a situation where there is no right to be appointed, like in this case, Jill, then in that case, there can be no claim that the rules of natural justice were breached. Yep, that's right. So she has no right. However, there's an issue about how she learned. Okay, it's not a question of implied expectation. I mean, a lot of us expect something. It could be about welfare benefits. So you apply for a welfare benefit, you expect that you will get it. That's not the same. The question is it a legitimate expectation? So is it a justified expectation? So in the case of Jill,
No, it's not.
Yeah, even in the case of Jill, even if her credentials fit perfectly, it doesn't mean that the other candidates don't have qualifications that also fit the description perfectly. Or, there could be questions of the interview process as well. Because it's never just a question of position description, right? when you apply for something. It's also a question of being interviewed, the way you deal with, potential colleagues if you're actually placed in a work environment. So in this case, there is no right. And because there is no right, there is no interest. She doesn't have an interest in this. And there is no when I speak of interest, it's more than just that I'm interested in it. We're talking of an interest that, let's say, may be backed up by a consideration because you probably paid for it. So it's not just that you're interested. That's not the notion of interest here. Okay, so when a person has no right or interest or a legitimate expectation in the decision of the decision maker, then there is no implied duty on the part of the decision maker to accord natural justice. So the implied notion of natural justice will only apply when the decision of the decision maker will affect the rights, interests, or legitimate expectations of a party. Okay, so the termination is different. Termination, when a position is terminated, obviously, it's clear that rights will be affected and impaired. Appointment, on the other hand, or applying for a position, that is something else. Promotion, I don't really know. It depends on the facts, because again, promotion is, you're already within the system, so it might be something else. Now, just to clarify before we close tonight's session, can somebody just explain to me, there are two aspects to the notion of natural justice. What were they again? There are two aspects to the notion of natural justice. What are they? Before we close tonight's session.
Was it hear the other side?
Yes. So
No bias. No.
Good. Thank you, Janet. So there are two aspects to the natural justice rule. One is that the prior hearing rule, the other person must always be given an opportunity to be heard if the implied duty is there. And secondly, there must be freedom from bias by the decision maker. So thank you. I guess that's it. Was there any question you wanted to ask before we end tonight's session? So we're good. So I'm going to schedule the makeup tutorial next week. I'm not able to do it this week, not tomorrow. Okay, so thank you very much again for being tonight. I'm glad you were all able to make it, and I hope to see you again next week. Okay? Good night. Thank you.
Thanks, Manjo. Manjo, when did you say you were going to put on that constitutional or other makeup tutorial?
I think I was going to do it next week. I'm not sure if I'm able to do it tomorrow. Yeah.
Okay, no problem.
Okay.
Thanks for that.
Good night. Bye.